the need to recommit 4 sections of the past electoral act for recommittal to the Senate. The recommittal proceedings is a peculiar proceedings that allow and effect consequential amendments. It is rarely done, but it is done when it is necessary. You will discover that about 2 weeks ago, we did one in respect of one university that we created, where we recommitted certain sections for further amendments. Today, we also invoked that provision of our standing order to recommit sections 43, section 52, section 63, and section 87 of the past electoral bill for recommittal, and subject to minor amendments at the committee of the whole. It was the amendment was taken. The substance of the amendment for section 43, it was seeking to introduce electronic voting machine as one of the materials that an agent of the party will be entitled to inspect, and also to empower INEC to provide, where they have the competence to do so, electronic voting machine for the election. So the amendment to section 43(2) relate to 2 subsections. One, section 43, subsection 1, which now reads, the commission shall provide suitable boxes, electronic voting machine, or any other voting device for the conduct of elections, so that this will allow INEC, when they have the necessary wherewithal and competence, they don't need to come back for us to introduce electronic voting machine as part of the materials they will use for election. It is hoped that this will strengthen them and avoid the situation that happened in the case of Wike and Peterside, whereby the Supreme Court did not agree that a car leader was part of the requirement of Electoral Act. Of course, we have amended that also provision under the existing law. As also section 43 subsection 3 was also amended by providing that the polling agents shall be entitled to be present at the distribution of election materials, electronic voting machine, and voting devices from the office to the polling unit. This allows agents to also be able to inspect and see the electronic voting machine before the election, so that it won't be as if they will say, if you have not introduced this amendment, electoral materials may be said to be too generic and not to include electronic voting machine. So when INEC has that instrument, they must allow polling agents to be able to inspect it. This, we believe, will strengthen transparency and allow oversight by the political party agents at the election. Then the second amendment relates to section 52 of the bill. The initial provision that was adopted by the Senate has 5 subsections, but what we have today has been reduced to 4 subsections. So what we did was to amend subsection 2 of 52 to now read, subject to section 63 of this bill, voting at an election and transmission of results under this bill shall be in accordance with the procedure determined by the commission, full stop. We remove which may include electronic voting, because the understanding is that the procedure determined by the commission may or may not include electronic voting if they so desire. But we want you to note that section 63 is being read to section 52 because it has addressed the concern that led to the initial subsection 3 of 52. You will recollect that the reason why section 52(3) was put in place was because of 2 reasons. One, the issue of disenfranchisement of areas where there are no network coverage, and also question of security of the network to prevent hacking. But upon further study of the bill that was passed, we discovered that Section 63 of the bill actually addressed those two challenges. And when you look at Section 63, which is included in this bundle, it provided for the procedure for counting of votes and announcement of results. So to have a clear picture of what Section 52(2) amended is done, you need to read Section 63. And Section 63 provides the presiding officer shall, after counting the votes at the polling unit, enter the votes scored by each candidate in a form to be prescribed by the commission as the case may be. 2. The form shall be signed and stamped by the presiding officer and countersigned by the candidate or their polling agent where available at the polling unit. 3. The presiding officer shall give to the polling agent and the police officer where available a copy each of the completed forms after it has been duly signed as provided in subsection 2. The presiding officer shall count and announce the results at the polling unit. Then 5. The presiding officer shall transfer the results, including the total number of accredited voters and the result of the ballot in the manner as prescribed by the commission. 6. A presiding officer who willfully contravene any provision of this section commit an offence and is liable on conviction to a fine not more than 500,000 or imprisonment for a term of at least 6 months. So what Section 63 has done is that all results must emanate from polling units. They must be counted, enter into the form and announced at the polling unit. After that, you may transfer the results in whatever manner you want to do the transfer. So that will serve as a paper audit for whatever result ultimately is collated after transmission has been done, either manually or electronically as may be determined by the commission. So it addresses the concern of coverage. So whether you have adequate network coverage in your area, you would have known the result of your area right at the point of your polling units. So whatever INEC does, whether they now carry paper trail or they transfer by Google Sheet or any other means, then that is a matter for collation of the election and the results. It also addressed the possibility of hacking. So if the result had been announced and result has been signed at the polling unit, so whatever happened, if there's any interference in the process of electronic transfer, then there will be a paper trail to correct that anomaly. So because we consider this section to have addressed the fear of lack of coverage, which may lead to disenfranchisement and possible hacking that may compromise security of the data, then it is on that basis that the Senate decided to adopt a new subsection 52 to section 52, which now provides that subject to section 63 of this bill, which means that votes must be counted, results announced at the polling unit, voting at an election and transfer of results under this bill shall be in accordance with the procedure determined by the commission. So it's now for INEC to determine the voting procedure and also the mode of transfer or transmission of results as the case may be. Then clause 63 was also amended in only subsection 5 to substitute the word transmit for transfer. So the primary must be monitored by the commission, and additional provisions were also inserted to strengthen the integrity of the direct primary. Subsection 3 is a new insertion. It provides that the procedure for the nomination of candidates by political party for the various elective positions by direct primary shall ensure that all aspirants are given equal opportunity of being voted for by members of the party and given opportunity to have agents for the purpose of monitoring the primaries. So all aspirants, cleared aspirants, will have agents and they have opportunity of voting and being voted for. Then subsection 4, the procedure adopted for the direct primaries shall be spelled out in the guideline to be issued by the political party and filed with the commission at least 14 days before the primary election. We don't want surprise. Whatever your guideline is, mode of your election, place, everything must be in the guideline that must be filed within 14 days of the primary election. Then subsection 5 provide that a political party shall maintain register of all its members and provide in the guideline for the conduct of the primaries that the register of its members shall be used for accreditation for the primaries. It's not just a situation whereby everybody will come. People who are not members of our party, like Sunday Aborisade, will say they want to vote at that election. It must be registered members, and the register must be made available for purpose of accreditation, so that you don't go and say because Itodo is contesting, you will go and carry all of you who are non-party member and say you want to vote. That must be a registered member. This therefore place obligation on all political party to have membership registered. Then see, the commission shall deploy personnel to monitor the primaries in all the centers where the direct primaries are held. This is also to strengthen the integrity of the primaries of political party. If you really want to ensure internal democracy, then INEC that will ultimately conduct election must certify that indeed a primary was held and it was conducted in line with the guideline. Then subsection 7 was slightly amended at the plenary. Every aspirant cleared by the party to contest at the primary shall not less than 14 days before the date of the primary be entitled to a copy of the guideline for the conduct of the primaries in which he or she is participating. So what we have done is that just as you have to file the guideline as a party with the INEC, cleared aspirant, and we are very clear, every aspirant as is clear, because there are some people who are not even aspirant of any political party, they will be parading themselves to do GoFundMe or whatever it is. Every cleared aspirant will be entitled within 14 days to have a copy of the guideline. And the others are that there may be a challenge to the conduct of primary in the Federal High Court in that regard. Of course, there will not be stay of proceedings or stay of election on the ground that there is a dispute as to the primary election. That is the overview of the amendment that have been passed. So the stage is now set for us to meet with our counterparts in the House of Representatives to have harmonized position. So this, in addition to what we have passed before, now represents the position of the Senate. Then the House of Rep will now meet together, possibly in the next 1 week, and then find harmonized position, which will be adopted at our plenary and sent to the President for assent. So in a matter of maximum 2 weeks, we will conclude all legislative action in relation to electoral bill. Thank you. Questions? Okay. Because when you have questions, you anticipate there will be a response. Where and when practicable is different from what we have adopted now. We say subject to Section 3. That means Section 3 has created circumstances. When I know I will answer the questions. I want to answer that question because I don't like people will go and say things that we did not pass. When you say where and where practicable, you have created an ambit that anything can come into it. You can say in Alimosho you can transmit results. In Oshogbo you cannot transmit results. That's the absurdity it will lead to. They call it reductum ad absurdum in logic. So in logic, so what we have said is this. So you don't confuse what we have said. What we have now said is that we have tied issue of transmission of results to Section 63. Before you talk of transmission, it's not a question of where and where practicable. You must have first count the votes, announce the results, and fill the form, sign the form at the polling units before you talk of transmission. So we have created transfer. We have even talked of transfer. So we have created a safeguard to ensure that no part of the country will be at disadvantage, whether there is network or no network. At least your result of your unit, you will know it and you take it to your house. So it's a word of difference at all, and people should not create any confusion. It is, and I still stand by my position. You cannot, in a legislation, give unfettered, nebulous, and uncontrolled discretion to anybody, where and when practicable. It's not done. So you can now ask your question. So I think that is clear. So we did not agree on the. We must be practical in what we are doing. If INEC is going to conduct presidential election on a polling unit basis. You are talking of conduct of primaries, which is on a ward basis. Which one is more difficult? I'm just asking. So if they can do that of polling unit, why should be the one for the ward being difficult? Then don't think for INEC. Section item 22 of the Constitution give us power to make law. If INEC now need additional resources and logistics, they will come to the National Assembly. We cannot say because of logistics not strengthening internal democracy of political party. There is no law that does not have its own cost implication. So if INEC think they will need resources to implement what you have done, the National Assembly is here. We have power of appropriation. But we cannot say because then also INEC does not just have officers aside EOs they have in all local governments. They have AEOs and they also have some other officers. Then they can always recruit ad hoc staff to go and monitor the election. Then to further argue, people who also said, they said there are so many political parties in Nigeria, what if they want to do the same thing? All of us know that in Nigeria today there are basically two political parties. We have other parties that possibly have one house of assembly, one house of rep. Will you consider that they have viable structure to conduct? And this one, the advantage it will give you is this. You will also be able to know, then when the time change now, and don't worry, you can also form your own political party ahead of 2020. You see, the advantage will also do is that all these are people just assuming that you can just put yourself on the ballot without having even minimum acceptance from the people. Now they are going to have register of member. All this one-man political party with respect will have to official out. You have to have genuine. There's nothing wrong in having many political parties, but they must be party with verifiable members, not briefcase or portfolio political party. Party matter is a serious matter, not just a matter for that you want to participate in national debate and you just said you are a presidential or a senatorial candidate. So in terms of logistics, yes, every legislation has its own logistics challenge. The National Assembly is there for appropriation if there's a need to strengthen capacity to be able to do so. But we cannot say because of that we want to give a less recommendation. Otherwise, if we say we don't make it mandatory for supervision, that means that INEC may or may not, I may go there. Then if people decide to do parallel primary, how do you know which one is authentic, which one is not authentic? We don't make a U-turn, and that's my answer. We did not make a U-turn. If you would listen to what I've said, you understand. So if you don't understand what I've said, that's all. I don't have anything to add. We did not make a U-turn, and I've explained what we have done. But if you don't understand what we have done and the context of it, I leave it to you. You can put it at your headline. Senate made a U-turn. Good. So that is your own. You are free. Yeah, you are free to. You are free to write whatever you like. You are free to like, and people who are educated, they will be able to know whether you are writing as a tabloid that your newspaper is or not. Tabloid have a way of writing their own something. So you are free. You can couch your very mischievous headline. You can do. Some of us also did campus journalism, but with the explanation I've made now, if your own interpretation is that we have made a U-turn, that is your own interpretation.
I will capture this comment as
capture, yes. That is your paper is a tabloid. Put it there. And you are free to say anything you like. It's part of your freedom of association. And that is why when you people say National Assembly is gagging the press, I laugh. Because you are free. Nobody has asked you to write what you cannot write. So when you now say they are gagging the press, I laugh. You have more than 400 radio stations in Nigeria that talk about our government positively, negatively, and in any other manner. Nobody has gone to go and knock them off. So your paper too have the right to abuse us, to knock us, and it's part of your right to freedom of expression. But what we know is that we have done what we think should be done because we have addressed the issue of security of our votes and issue of disenfranchisement of voter that we had a pressure for. But all other headlines, we are acceptable to it. We are politicians. We have very thick skin against such bannerless communications. What I've told you, you are still saying the same thing. What we have told you is this. The reason why we took our position and we were hard on that one had now been addressed. Issue of security of votes and issue of disenfranchisement of voters. So you are free to come with your own interpretation. Then And I also want to address the mischief that was also pointed out at that time. They said APC decided to vote against electronic transmission, as if APC is also not in the majority in the House of Rep. If APC's position is to vote against electronic transmission, why is it that the majority of APC in the House of Rep voted differently from what has been voted in the Senate? It's because we voted according to our understanding of the position. No party gave us a mandate that we should vote in a particular direction. And that is why our majority in the House of Rep voted differently, and us in the Senate, we voted differently. But in any event, there's nothing wrong in political party in our caucus giving us direction as to how we vote. And that's why we have chief whip in our own party. And every party has its own whip to ensure that party positions are taken. But I will tell you that it is never a position of APC that we are voting against electronic transmission. But everybody is free to write whatever they like. Of course. It's never our position. It addressed to the clerk of the National Assembly. Even I don't have copy, and I've never seen the copy of this. It's not our job. Our job in the Constitution, including that of the Senate President, is to make law, perform oversight function, and also to appoint, to confirm appointment. Our own, we are not the one running bureaucracy of the National Assembly as elected senators. So the budget of the National Assembly is not the budget of senators. It's the budget of the bureaucracy of the National Assembly, headed by the clerk of National Assembly. So I will implore you, that question asked from Architect Ojo, who is the clerk, Latude Ojo, who is the clerk of the National Assembly. I'm not privy, and I don't think we consider our budget anywhere at the plenary. I don't think whether you have seen them bring our budget before us there. So ask Architect Ojo. Those people that said that, they want to set us against our governors. As far as I'm concerned, the governor of my state is my leader, so I'm not against my governor. So that question is just to whip up political sentiments. As far as I'm concerned, though, I'm a senator from Osun Central. My governor, Boyega Itola, is from Osun Central. I don't have any problem, and I don't have any tough to fight. So maybe your own senator may have a problem with this. So, but I've also known that some elements in the opposition party, I think Vanguard carried a story by Umaru carried a story about the reason why the primary is not so like that. For me, I regard what he's saying is speculation, and it has no basis. The truth is that if it is a gang up, just like you have said, even before, what we did was to strengthen what the House of Rep adopted. They have adopted the primary. So when we want to go to the conference, we need to have safeguard to ensure that that primary has meaning. So ordinarily, we need not come before the plenary again on the issue of direct or indirect. What we don't need to do as members of conference committee to agree with the fashion of the House. But we felt that the fashion itself does not go well in ensuring the integrity and free and fairness of that process. So nobody has any governor in mind. And in any event, some people who are in the Senate, they also hope that one day they will be governors. So they could not be making law against themselves when they become law. And what I know is that there's a difference, word of difference between political processes and legal processes. The political processes will ultimately determine who will emerge as candidate of every political party, irrespective of what procedure you put in your law. So rather than creating unnecessary issue, which bordered on speculation as to motive to do it, my own motive in accepting the primary is that I believe it will entrench internal democracy. And the present governor of Osun, I give you an example, emerged through a direct process primary. Because at that time, our party said you can choose direct or indirect. He emerged through direct primary. So is it a governor that is elected direct primary that we are using direct primary to fight? So we need to get that. So sorry, I hope I'm not. So that is the point. There's nobody is fighting any governor, and it's not healthy for anybody to say you are fighting leaders of our political party at the governorship level. We are done. Okay, no,